Are both parties present and ready to proceed?
The plaintiff is here and ready to proceed, Your Honor.
Okay.
The defense is ready to proceed, Your Honor.
All right. We ready to open?
Would you like us to state appearances and preliminary matters first, Your Honor?
Sure.
Appearances from the people.
Okay.
Good morning, Your Honor. My name is Logan Falkel, and along with my second chair, Shayla Dutta, we represent the estate of Ethel Marks on behalf of her deceased daughter, Jessica Marks.
Defense, do you wish to make appearances as well?
Yes, Your Honor. Good morning, Your Honor. My name is Jordan Rein, and today I'm joined by my co-counsel, Lily Radowski. Together, we represent the defense in today's case, Sonny's Rooftop Bar.
Okay.
Preliminary matters, Your Honor.
Go ahead.
We ask that all witnesses be sequestered, barring the defendant.
Defense, do you have a position on that?
We have no objection to that.
By defendant, Ms. Falkel, I'm assuming you mean the owner of the bar.
Yes, the representative of the defendant.
Makes sense.
Sonny's Rooftop Bar.
Okay. What's next?
We would also like to constructively read the stipulations into the record.
Denied. If you want to read them, you have to actually read them, and that's going to count against your time, obviously. So read them if you want. Otherwise, we're not going to assume they're read.
Okay. And with that, we are ready to proceed.
Okay. Defense?
Your Honor, the defense would like to ask your preference for the sharing of demonstratives. Would you prefer that we ask permission before sharing them, or just make a narrative for the record?
Demonstrative. So when you say demonstratives, you mean things that are not included on the joint exhibit list. Is that right?
That's correct.
To the extent that your opponent has seen them, I'll prompt you and your colleague as to whether it's a demonstrative that you've shared previously, and ask your colleague if she has an objection to the demonstrative being displayed. So why don't you just ask permission, and we'll take it up at that point. Does that make sense?
Yes, Your Honor.
Okay. What's next?
When exhibits are entered into evidence, we ask that they just be considered constructively published to the jury.
Same with the stipulations. To the extent that you want to publish something, I understand what you're saying. If we were in a real courtroom, you would hand copies out or something to that effect. But to the extent that you want to publish something, we won't assume things are published. If you want to publish it, you've got to actually screen share. Okay?
Yes, Your Honor. And finally, we just ask that if at any point the court cannot see or hear a lawyer or witness testifying, that they may intervene.
Yeah, I'll let you both know if there's a technical issue.
With that, Your Honor, we're ready to proceed.
All right. Plaintiff, do you wish to make an opening statement?
We do, Your Honor.
Okay. We're about to hear opening statements from the plaintiff. I ask our scoring judges, if possible, to switch to speaker view so you can see plaintiff's counsel best, but it should look the same either way because I'm going to turn my video off in a second. So, counsel, whenever you're ready, you can proceed.
Yes, Your Honor. May it please the court. Jessica Marks was a 19-year-old college student. She was in LA on her spring break. On the night of March 24th, her and her best friend, Morgan Levin, went out for a good time. They chose the defendant, Sonny's Rooftop Bar, because it was notorious for serving alcohol to minors. That night, Sonny's lived up to its reputation. They served Jessica drink after drink after drink. By midnight, she was falling down drunk. But still, the defendant had not cut her off. After Jessica left the bar, she got in her car and barely made it a quarter mile down the highway before veering off the road and into a ravine. She was pronounced dead at the scene. Members of the jury, her life was cut short because Sonny's Rooftop Bar did not cut her off. Good morning, members of the jury. My name is Logan Falkel, and along with my second chair, Shayla Dutta, we represent the estate of Jessica Marks. We have brought a wrongful death suit against the defendant, Sonny's Rooftop Bar, because they continued to serve Jessica even though she was obviously intoxicated. And it was that over-serving that caused her death. Members of the jury, when a bar overserves an obviously intoxicated minor, they are liable for any harm that comes to that person. Today, we must prove 3 elements to meet our burden that they are liable for Jessica's death. First, we must prove that Jessica was a minor. Second, that Jessica was obviously intoxicated. And third, that intoxication was the cause of Jessica's death. First, you'll hear from Morgan Levin. She was Jessica Marks's best friend with Jessica the night that she died. Miss Levin will describe that night for you, how the two arrived at the bar at 9 o'clock, and over the next 3 hours, the defendant served Jessica alcohol. As she became more and more intoxicated, Miss Levin will tell you that after 10 drinks, Jessica Marks was falling down drunk. Miss Levin will also tell you that the defendant knew Jessica was drunk. Jessica interacted with the owner of the bar, Sonny Mehta, up to 8 times. You'll hear that during one of those interactions, the defendant joked about Jessica's level of intoxication. This was after Jessica fell down the stairs. But members of the jury, you won't have to rely solely on Miss Levin's testimony. We'll show you a video taken of Jessica less than an hour before she died. When you see that video, you will have no doubt in your mind that Jessica was obviously intoxicated. Ladies and gentlemen, you'll learn that Jessica's BAC was 0.16 when she died. That's twice the legal limit for an adult and 16 times the legal limit for a minor like Jessica. The defense will claim that Jessica wasn't obviously intoxicated, that the defendant shouldn't have known about her condition. Well, the facts will tell a different story. Jessica Marks's life was cut short because the defendant didn't cut her off. Because of that, we'll ask that you find Sonny's Rooftop Bar liable. Thank you.
Thank you, counsel. Defense counsel, do you wish to make an opening statement?
I do, Your Honor.
You can proceed whenever you're ready.
Can you all see and hear me well?
See and hear you just fine. Thank you.
She drove her own decisions. The plaintiff just got up here and talked to you about what happened at Sonny's Rooftop Bar that night. But today, I'm going to talk to you about what happened before. Because you'll see the most important thing that happened that night didn't happen at that bar. It didn't happen as Miss Marks was leaving. It happened hours before, when Jessica Marks started making her decisions about driving and then drinking and then driving again. She drove her own decisions. Today, the plaintiff is suing Sonny's Rooftop Bar for the wrongful death of Jessica Marks. It's their job and their burden to prove, with the preponderance of the evidence today, that Sonny's Rooftop Bar served alcohol to an obviously intoxicated minor, and that alcohol caused the death of Jessica Marks. You'll see they simply won't be able to do that today, and that Jessica Marks drove her own decisions. You'll hear today that hours before Miss Marks got in the crash that ended her life, she made 3 important decisions. You'll find out from Morgan Levin that at the beginning of the night, she and Miss Marks each had a glass or 2 of wine. You'll hear that at this point in the night, Jessica Marks made her first big decision. You'll hear Miss Marks decided to drive all the way to Sonny's Rooftop Bar. You'll see before Miss Marks ever got to that bar, she'd made her second decision. You'll hear she'd made the decision to use the fake IDs she'd had created for spring break. to drink at Sunny's rooftop bar. And it'll become clear to you today that before Miss Marks ever stepped foot in that bar, before she ever had a drop of alcohol there, she'd already made her third decision. She'd already made the decision to go to that bar, to drink at that bar, and then drive back home. Members of the jury, we don't believe that Jessica Marks was a bad person. But Miss Marks made decisions, mistaken decisions, but decisions nonetheless. So I'm going to ask you to keep an eye out for those three decisions throughout the trial today. You'll hear from Sunny Meta, who will tell you about Miss Marks, Miss Levin's time at the bar that night. You'll hear Mr. Meta was trained to see signs of intoxication, that he never saw Miss Marks slurring her words, her eyes red or watery. He never saw any symptom whatsoever of intoxication. You'll find out Mr. Meta never needed to cut Miss Marks off because she was simply never obviously intoxicated. She drove her own decisions. You'll hear about those three decisions Miss Marks made several times throughout the trial. And keep an eye out for the fact that Miss Marks had every opportunity to change that plan. And unfortunately, she never did. So at the end of trial, I'll come before you and I'll ask you to find Sunny's rooftop bar not liable. Thank you.
Thank you, counsel. Plaintiff, you ready to call your first witness?
We are, Your Honor.
Okay.
Plaintiff calls Morgan Levin to the stand.
Before we proceed with the testimony, I'd remind our scoring jurors to, if possible, switch their view to gallery view, which by way of reminder is in the top left corner of your screen. Click view and click gallery view. That way you can see the two advocates and the witness and me on the screen all at the same time. Ms. Falkel, whenever you're ready to proceed, you can go ahead.
Of course, Your Honor. Please state your full name, spelling the last for the record.
Morgan Levin, Levin.
Good morning, Miss Levin.
Good morning.
How old are you?
Oh, I'm 21.
What do you do for a living?
Well, I'm in college right now. I go to UCLA. I'm a biology major.
I'd like to ask you some questions about March 24th of 2019. Do you remember that day?
I'll never forget it.
What happened?
That was the day my best friend, Jessica Marks, died.
Were you with Miss Marks that day?
Yeah, I was.
What were you two doing?
Well, she had come out for the week to LA to visit me, and that night we had gone to a bar.
Did you purchase alcohol at this bar?
Yeah, we did.
This was 2 years ago. How old was Jessica at the time?
2 years ago, she would have been 19.
I'd like to talk with you a little bit about that bar. Could you tell me what bar you went to?
Oh, it was called Sunny's Rooftop Bar.
And why did you choose Sunny's?
Well, Jessica wanted me to choose a bar that didn't card. And Sunny's has got a reputation of not carding or asking for IDs from minors like we were at the time.
How long were you at Sunny's for?
I'd say about 3 hours, 9 p.m. to 11:45, so almost that much.
How did you get there?
Jessica drove.
When you arrived at the bar, who was your server?
It was Sunny Meta. That's what he introduced himself as. Yeah, he was taking our orders.
And how many times did you and Jessica interact with Sunny?
We interacted. He came to our table a lot to take our orders and then bring us drinks. So I'd say about 8 to 10 times.
Were these long interactions?
Kinda. The most it would be was like 1 minute.
I'd like to talk about what you ordered from Miss Meta. Could you describe that for the jury?
Yeah, we ordered, I guess, 8 drinks and a bottle of wine.
Of those drinks, how many did Jessica have?
Well, Jess had 6 drinks and the bottle of wine, which was maybe 2 to 3 glasses.
Do you have any record of the alcohol you and Jessica ordered?
Yeah, I do. I had a receipt that night.
Did you take any photos?
I also took photos, yeah.
May the record reflect I'm showing what's been marked for identification as exhibits 11 through 16. Do you recognize these, Miss Levin?
Yeah, I do. These are all the photos I took on March 24th at the bar.
Hey, Ms. Falkel, can I just pause for a second? Are these pre-admitted?
No, Your Honor, we're showing them for identification.
Okay. Miss Levin, do you have a copy of the exhibits?
Not with me? No.
You don't have an electronic copy?
I can see what's on the screen.
Okay, but you don't have a separate copy.
No, I don't.
All right. In that case, then we will allow these to be constructively displayed for authentication purposes, assuming our jury, this is outside of the presence of the jury. Go ahead. Sorry about that.
Thank you, Your Honor. I have a question. In the future, will exhibits be constructively shown outside the view of the jury, or should we make a record of that?
Seeing as though it sounds like one of our 2 witnesses who are going to be testifying doesn't have a copy of the exhibits, I guess it makes sense to just do it this way for the remainder of the trial. If that's okay with both of our advocates, you can constructively display as you're doing now.
Yes, sir.
Okay, continue.
Thank you. Miss Levin, do you recognize these photos?
Yes, I do. These are all from the bar that night.
Who took them?
I did.
What time were they taken at?
Well, they were earlier in the night, maybe 9 or 10.
Are they fair and accurate depictions of the photographs that you took?
Yeah, they are.
At this time, the plaintiff moves exhibits 11 through 16 into evidence, Your Honor.
Any objection?
No objection for 11 through 16, Your Honor.
So admitted.
Permission to have them published to the jury, Your Honor.
I think you're already doing that, so permission retroactively granted.
Okay. Now, Miss Levin, I'd like to go through the alcohol you and Jessica ordered. What did Jessica order first?
Well, as you can see in the first 2 photos, it's a bottle of wine. I think it's called Decoy Red Blend. I had 1 glass. Jess had like 2 or 3.
What did you order next? What did Jessica order next? Excuse me.
Well, next, Jessica had a White Claw, as you can see in the next photo, and she had a beer.
Did Jessica have any other drinks that night?
Yeah. Well, in the next photos, she got another White Claw, and she also had this thing, I think it was a rum and Coke.
Will you now please describe the last 2 photographs for us?
Of course. Well, they're all the drinks I talked about before, and then there's 1 more White Claw in the 16th one. And then, there's also a water carafe.
Does the alcohol you see in front of you accurately depict the amount of alcohol you saw Jessica consume on March 24th?
No, actually, there was 1 more drink. It was like liquor shots. I think they were something like green tea shots. Jessica had them before. She said they were really good.
At any point that evening, did Jessica appear to be affected by the alcohol she consumed?
Yeah. Throughout the night, she just got drunker and drunker.
Objection, Your Honor. As to speculation, may I be heard?
Sure.
Your Honor, this witness saying that Jessica Marks was drunk is speculation. This witness didn't know specifically what Miss Marks's blood alcohol was. She can testify to any symptoms she may have seen, but simply stating that she was drunk is a scientific fact that would need more background.
Ms. Falkel.
Your Honor, witnesses are entitled to opinions based on rational perceptions. She was with Jessica the entire night. She'd seen Jessica drunk before. We can lay that foundation if you'd like. She would have been able to tell if Jessica was drunk or not.
What is the witness going to say, if anything, about the way her friend appeared? Are you going to get into that?
Yes, Your Honor. If we may proffer, we're going to be eliciting the symptoms of Jessica's intoxication that Morgan Levin saw herself.
Okay. I find that a lay opinion as to whether someone that a person observes is intoxicated or drunk is a proper lay opinion, and especially considering that the witnesses, as counsel represents, going to testify as to the specific symptoms that she saw. I think that either way it's appropriate. And so I'm going to overrule the objection. Continue.
Yes, Your Honor. So did Jessica appear to be affected by this alcohol?
Yes, she did.
And how did she appear to you?
Well, her eyes got really red and watery, and then she was talking really loudly, and sometimes I couldn't even make out what she was saying. It didn't make sense. And one time she even stumbled down the stairs.
Is there any record of how she appeared that night?
Yeah, I took videos that night.
Showing what's been marked for identification as Exhibits 6 and 10 constructively outside the view of the jury. Do you recognize these?
I do.
Are they fair and accurate depictions?
Yes, they are.
At this time, the plaintiff moves Exhibits 6 and 7 into evidence, Your Honor.
Any objection?
Yes, Your Honor. I object to both Exhibit 6 and Exhibit 10 as to lack of foundation. Opposing counsel hasn't laid the proper foundation for the points in the night when they were taken and what they actually depict. We're not sure. This witness needs to lay the foundation of what's actually in these videos, and if they're even reflections of how Miss Marks was really acting that night, or if they're something that Miss Marks simply made up.
Ms. Falkel.
We'll lay that foundation, Your Honor.
Okay, then I'm not going to rule the objection. And counsel, you can lay some additional foundation to the extent that you still have an issue with it. Counsel, you can re-raise your objection. So I'll allow you to continue and we'll take it up should there be an issue and a few questions.
Who took these videos, Miss Levin?
I took the videos.
And when were they taken?
Well, the first one where she's holding up the glass of wine, that one was taken at the Airbnb before we went to Sunny's bar. And then the second one was taken at the bar at around 10 or 11.
Are they fair and accurate depictions of the videos that you saw taken and you took?
Yeah, they are.
We now move Exhibits 6 and 10 into evidence.
Counsel.
Your Honor, I believe the proper foundation has now been laid for Exhibit 6. However, I re-raise my foundation objection to Exhibit 10. If I may, I believe opposing counsel is offering this to try and demonstrate how they think Miss Marks was acting that night. I haven't seen the foundation that video is actually an accurate reflection of that, especially since the defense today will dispute the fact that that video is how Miss Marks was acting.
Ms. Falkel, what's your response?
Your Honor, first of all, we're going to play Exhibit 10, which is the video that Miss Levin took of Jessica Marks. Next, we'll ask her whether or not this video shows the Jessica that she saw that night.
Okay. Ms. Rein, I think your concerns go, am I saying that correctly, Rein, your last name?
It's Rein, Your Honor. But
Rein, okay. I knew I was going to get it wrong. Ms. Rein, I think your concerns go to weight, not admissibility, and so objection overruled.
Now, if we could play Exhibit 10. Are you able to hear that, Miss Levin?
I'm not, sorry.
One moment, please.
Take your time.
Thank you.
Kind of like a Philly bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress.
Does this depict how Jessica appeared to you on March 24th?
Yeah, that's how she was acting.
Was Jessica served by Sunny's bar after this video was taken?
Your Honor, point of order, if I may, I believe time has elapsed.
Oh,
If
I apologize.
opposing counsel just keep it to one or more questions, I would appreciate that.
Okay, it looks like our second chairs agree on that. And so, yeah, Ms. Falkel, I'll allow you to wrap your thought up and then we'll go from there.
Of course, I completely apologize. One more question. Did Sunny's bar serve Jessica alcohol after this video was taken?
Yeah, they served us all night after that.
Thank you, Miss Levin. No more questions, Your Honor.
Cross?
Yes, Your Honor, just one moment and I'll get started. Good morning, Miss Levin. I have a few questions for you today.
Okay.
Jessica Marks picked you up from your dorm room on March 24th, 2019, didn't she?
Yeah, she did.
The two of you went back to Miss Marks's Airbnb.
Yes, that's what we did.
So let's talk about some of the decisions that were made there. While you were there, you had a glass of wine, didn't you?
I did, yeah.
Miss Marks also had a glass of wine, correct?
She had one or two, yeah.
Your Honor, permission to share a demonstrative aid?
Has Ms. Falkel seen this?
I don't believe so, Your Honor.
I've not seen the.
All right, then let's display it constructively outside the presence of the jury. We can stop our time for this, obviously, and Ms. Falkel can look at it and see if she has an objection.
We have an objection as to foundation, Your Honor.
Okay, what's your objection? What with respect to foundation you think is going to be lacking?
That there was a specific plan involved in the decisions made. It says in decision 2 that there was a plan to drink at the bar. We do not believe there was a plan that will be able to be elicited on examination today.
Miss Rein?
Your Honor, if I may make an offer of proof,
Sure.
I will lay this foundation through this witness. You'll hear that Miss Marks and Miss Levin had both been using fake IDs that week to get alcohol, which I'll ask Miss Marks about, or Miss Levin about. I'll ask Miss Levin specifically about her plan. I'm not going to ask her about what Jessica was thinking or what she specifically intended. I'll ask what Miss Levin believed the plan was, and I'll lay the foundation that they did in fact have the opportunity and the resources to plan to drink at that bar.
Okay, to the extent that the words on this, and we're outside the presence of the jury, obviously, to the extent that the words on this demonstrative aid are an accurately preserve the witness's words, I'll allow it. It doesn't have to be exact, but close at least. But to the extent that the witness doesn't agree with the characterizations on this demonstrative aid, I'm not going to allow you to display it, and I'll strike it. And so, Ms. Falkel, to the extent that you think the foundation's not been laid before these individual kind of blurbs are displayed, you can re-raise your objection. But I'm going to at least allow Ms. Rein to attempt to lay that foundation. So overruled pending the foundation.
Miss Levin, you and Miss Marks decided to go to Sunny's rooftop bar that night, didn't you?
Yeah, we did.
So let's talk about that first decision then. Jessica decided to drive all the way to Sunny's rooftop bar, correct?
Yeah, she drove me and her.
Sunny's rooftop bar was all the way in Malibu, wasn't it?
Yeah, like a 20-minute drive with no traffic.
So you didn't just choose to go to a bar near UCLA then?
No, because we wanted one that didn't cod.
Miss Levin, if you could stick directly to my questions, please. So you didn't choose a bar near UCLA, did you?
No, we didn't.
You didn't choose a bar you could walk to?
No, I don't know if there was any around her place.
Ms. Levin, the two of you didn't decide to take a taxi all the way to Sunny's rooftop bar.
No, Jess had a rental car.
Ms. Levin, the two of you never decided on a designated driver, did you?
No, we didn't.
So, Ms. Levin, you had fake IDs over spring break, didn't you?
Yeah, that was Jess's idea.
The two of you had used them in order to get alcohol that week.
Not my proudest moment, but yeah.
Your Honor, Ms. Rudowski, if we could get that demonstrative back. So, Ms. Levin, you had your fake IDs with you that night, didn't you?
We did.
You were going to use them to get into that bar so you could drink. Isn't that true?
We used them to get into the bar, yeah.
Ms. Levin, specifically, when you went to that bar, you thought you were going to be drinking alcohol at that bar. Isn't that true?
Well, I thought I'd have a couple glasses, yeah.
Thank you, Mr. Dowski. So let's talk about some of the decisions that you and Ms. Marks made at the bar. When you got there, the two of you ordered a bottle of wine, didn't you?
We did.
And after you had that bottle of wine, you didn't call a taxi and ask to be picked up at 11:45.
Well, we had drinks after that, so no, we didn't call a taxi after the wine. We wanted to stay there longer.
Just to be clear, you didn't set up a way to use a taxi to get home at the end of the night.
No, we didn't.
You didn't call a friend and ask them if they could pick you up later, did you?
No, we didn't.
You didn't see if there was a way that you could use public transportation to get back home after you had those drinks.
We had been driving to and from bars all week, so I assumed we'd be driving home, unless we were too drunk.
Ms. Levin, just to be clear, Ms. Marks and yourself have been driving after drinking the rest of the week. Is that what you're testifying to?
Yeah.
Ms. Marks, that night after that wine, you ordered more drinks.
Yeah, we did.
And after you ordered each of those drinks, you never found a way to use public transit to get home.
I did.
Well, I mean, while you're at the bar, after you had sat down to drinks, at that point, you didn't find a way to use public transit.
Well, I called for an Uber at the end of the night.
But before that, you didn't do that, correct?
Before the end of the night? No, I wasn't thinking about it.
Ms. Levin, let's talk about what happened at the end of the night. You left the bar at 11:45.
Yeah, we did.
And at that point, you were feeling a bit buzzed, weren't you?
I was. That's when I called the Uber.
So you called an Uber. You asked Miss Marks to get into that Uber with you, didn't you?
I tried to get her to come in with me, but she wouldn't do it.
Mr. Dowski, if we could get our demonstrative back. Miss Levin, Miss Marks didn't get into the Uber with you. She drove instead, didn't she?
Yeah, she did.
Thank you, Your Honor. I have nothing further.
Okay. Ms. Falkel, do you rest, or is there anything else we have to take up before you do that?
I'd like to ask I'm over time. Excuse me. We do have one more matter to take up. We'd like to publish exhibits 22 and 23 to the jury.
Are these pre-admitted exhibits?
They are.
Okay. I'm not going to allow you to publish them because of the time issue, but the jury does have them, and we'll be able to look at them during deliberation. So with that,
Thank you.
you rest?
With that, we rest.
Okay. Miss Rein, are you going to be putting a case on?
Yes, Your Honor. At this time, the defense calls Sonny Meta to the stand.
All right.
Good morning, Mr. Meta. Could you please introduce yourself for the jury?
Good morning, everyone. My name is Sunny Meta.
What do you do for a living, Mr. Meta?
Well, I used to own a bar called Sunny's Rooftop Bar, named after me. But now I'm just, in between jobs looking for a new business opportunity.
Mr. Meta, did you know Jessica Marks?
Not very well, but she went to my bar one night.
What date was she at your bar?
March 24th, 2019.
Was she at your bar alone that night?
No, she was with a friend.
What was that friend's name?
I believe Morgan Levin. I think she was just here.
Mr. Meta, let's talk a little bit about your time as a bartender. Had you ever had someone who was drunk in your bar before?
Yeah, it was a bar in the middle of California. Yes, I've had people drunk there before.
What general signs might someone show if they're drunk?
Well, as a bar owner in California, we all had to take this training course where we were certified in detecting what's called obvious intoxication. So what that meant was if someone was, watery or bloodshot eyes, unable to order for themselves, passing out, stumbling, anything like that, then, we'd be able to detect that they were obviously intoxicated.
Mr. Meta, what do you do if you see someone showing a lot of those symptoms?
Well, I try and be as polite as I can, but I cut them off. It's my legal duty.
Objection, Your Honor.
Grounds?
Improper character.
How so?
As to cutting people off in the past, they're using this to show conduct and conformity.
Ms. Rein?
Your Honor, we're not using this evidence to show that Mr. Meta had cut people off before and that he did it again. We're using this to show that Mr. Meta knew what to do if he saw those signs, and that because he didn't see those signs that night, he didn't need to cut Jessica Marks off.
May I be heard, Your Honor?
Sure.
We believe that they're actually using this testimony to show that Sonny Meta had acted responsibly in the past and would therefore have acted responsibly in the case of Jessica Marks. That's not permissible.
Ms. Rein?
Your Honor, that's not what we're using this testimony for. We're using this testimony to show that Mr. Meta knew what to do, and that in the absence of those signs and symptoms in Ms. Marks, he knew he didn't need to legally cut her off.
Yeah, I understand that. I think you can ask the witness whether he knew what the signs were and what signs would need to be present to cut someone off. But I think what Ms. Falkel's objecting to is you taking that next step and saying, and so in the past, I have cut people off. And so I'm going to sustain the objection as it relates to this witness cutting people off previously. I'm going to ask the jury to disregard it. But the remainder of the testimony regarding this witness's knowledge of the signs and symptoms of a drunk person that would require him to cut people off, I will allow that testimony. But that part about what he did in the past is going to be stricken.
Yes, sir.
Sustained.
Mr. Meta, what does the law tell you have to do if you see those signs in one of your customers?
Oh, I'd have to cut them off.
Did you ever see Jessica Marks become obviously intoxicated that night?
No, again, I'm trained to detect those symptoms, and I was checking for them throughout the night with Jessica Marks, but I didn't ever see them.
Let's talk a little bit about what happened that night. What time did Miss Marks and Miss Levin arrive?
Around 9 p.m. as best I recall.
Were they both ordering drinks?
Yeah, throughout the night, I'd say they probably ordered about equally.
And when they were making those orders, how many times did you end up visiting their table?
Well, with the ordering, the serving, and anything else, I'd say probably 8 to 10 times throughout that night.
In those 8 to 10 times, were you able to see how Miss Marks was acting?
Yes, that's what I was there, to do. In addition to taking orders and serving drinks, I was checking for those signs. And I mean, as much as I wish she was showing those signs, so I would have had a reason to cut her off, she wasn't.
Objection, relevance.
What part of his answer do you think is irrelevant?
Of him wishing that she had shown those signs, that holds no bearing on the elements today's case.
Ms. Rein?
Your Honor, the testimony this witness just gave is incredibly relevant. He's telling you that he wishes he had seen those signs. He's reinforcing the point that they just weren't present that night, which goes straight to the matter at hand today.
Overruled.
Mr. Mehta, did you hear Ms. Levin testify earlier about the symptoms she claimed she saw in Ms. Marks that night?
Yes, I did.
Your Honor, permission to display a demonstrative aid.
Has Ms. Falkel seen this?
I don't believe so, Your Honor.
Is this not the same one we saw earlier?
No, it's separate, Your Honor.
Okay, so I'm going to dismiss the jury briefly, constructively, and you can display it. Ms. Falkel will look at it. We'll take it from there. Ms. Falkel, take as much time as you need.
We don't have a problem with this exhibit, Your Honor.
All right, bring the jury back in whenever you're ready to go, Ms. Rein.
Mr. Mehta, did you ever see Ms. Marks slurring her words that night?
No.
Did you ever see her lose her coordination?
Once again, no.
Did you ever see her appear tired?
No.
Mr. Mehta, did you see her eyes become bloodshot or watery?
Again, I checked for all these all night, and no, I didn't see it.
Did you see Exhibit 10 earlier when they played it?
Yes, I believe so.
Well, how was Ms. Marks acting in that video compared to the rest of the night?
Well, again, in the 8 to 10 times that I interacted with her that night, she seemed fine, and I was checking for those signs, and yeah.
Did you ever that night become concerned about either Ms. Marks or Ms. Levin?
Well, as I previously said, I never was concerned for Miss Marks, but Miss Levin, well, she was never at a point of obvious intoxication, but I was keeping a closer eye on her.
Why were you keeping a closer eye on her?
Well, as I said, I'm trained to identify those symptoms, so I started to see that she could be developing those. She could be tired or have bloodshot eyes. And again, I was just checking to make sure those symptoms didn't develop, at which point I would have had to cut her off.
Mr. Mehta, did you ever ask Ms. Marks and Ms. Levin who was going to be driving home that night?
Yes, I walked up to their table and asked, and I said, I hope this one's not driving.
Who did you mean you hoped wasn't driving?
Objection, hearsay, Your Honor.
Response?
Your Honor, we're not using Mr. Mehta's words for the truth of the matter asserted that he actually hoped Morgan Levin wasn't driving. This goes to lay the foundation for Ms. Marks's response to that.
What is her response going to be? Make an offer of proof.
Yes, Your Honor. Ms. Marks's response was that she was going to be driving, that she planned to drive at the end of the night.
Ms. Falkel?
In that case, we ask for a limiting instruction that it don't be taken for the truth.
Okay, I will give that limiting instruction by agreement, and we will admit the statement for that limited purpose. Proceed.
Mr. Mehta, who did you mean shouldn't be driving?
Oh, well, I was very clear. I pointed at Morgan, and then I looked at Jessica, and I said, I hope this one's not driving, pointing at Morgan.
After you said that, what did they tell you?
Well, Jessica clarified that she would be driving, which at the time relieved me because, again, she wasn't showing symptoms as much as I wish she maybe would have.
Mr. Mehta, did you see Ms. Marks, Ms. Levin leave that night?
Yeah, I saw them walk out the door.
Did Ms. Marks trip on the stairs when she was going down them?
No, absolutely not.
Did she seem to have any trouble at all walking down a flight of stairs?
No, she seemed fine going down the stairs.
How was Miss Levin walking down those stairs?
Again, it was, a little bit more worrisome, but again, not to the point of obvious intoxication, but yeah, a little more worrisome.
So, Mr. Mehta, that night, did you ever see a reason that you would need to cut Miss Marks off?
No, no, she was fine that night. I really wish she would have shown signs, but if she didn't, which I checked for, I couldn't have done anything, and I couldn't do anything.
So, Mr. Mehta, how was Jessica Marks acting when she walked out of your bar that night?
She seemed fine.
Thank you, Your Honor. I have nothing further.
Cross?
Yes, Your Honor. Good morning, Mr. Mehta.
Good morning.
You just talked about Jessica's level of intoxication, about her appearance. She looked sober to you?
Yes, she seemed sober based off of the signs I was checking for.
So your testimony is that she was completely sober at your bar?
Again, she seemed that way to me, yes.
That's not what you told the police, though, was it?
I remember talking to the police briefly, but I don't remember exactly what I said.
I'll show it to you. If I could show you what's been admitted and published as Exhibit 23. This is the police report. If I could direct your attention to the last couple of lines. Do you see there what it says, Mr. Mehta? Yes, it says Jessica Marks. So you spoke with the police.
Yes, yes.
You told them, Sonny said that Jessica Marks was a typical buzzed girl. Do I have that right?
Exactly, yeah. She wasn't at any near a point of obvious intoxication when she was at my bar, yes.
Well, you called her a typical buzzed girl, but you just testified that she was completely sober.
Again, ma'am, just to be perfectly clear, I don't have a breathalyzer at my bar, but
I'm not
she
asking.
seemed...
I'm not asking that.
I know. She seemed sober to me is what I'm trying to say.
Sober and buzzed the same thing to you, Mr. Mehta?
Again, in terms of, what I can do with either of those, it is the same. I can't cut someone off for being a little buzzed in the same way that it seems as if they're perfectly sober, or if they're fine that night, then I can't cut them off. I can only cut them off if they're showing symptoms.
Yes or no? Are buzzed and sober the same thing to you?
Again, in this case, or in a situation where I can cut someone off,
Objection
I'm
on
very
responsive.
similar.
I think the witness was being, well, I want to hear the rest of his answer, and then I think he was being responsive up until the point where you objected, at least. So, overruled.
You can finish your answer, Mr. Mehta.
Thank you. As I was saying, again, they're not exactly the same, but I have the exact same ability to stop someone when they're buzzed or if they're sober. I can't do anything in either case.
Mr. Mehta, I think you were a little bit not responsive on that last part, and I'm going to keep to my word. Just respond to Ms. Falkel's questions only. You'll get a chance on redirect. Explain. Proceed.
Of course, sir.
Mr. Mehta, you served Jessica all night,
Yes.
and she was a minor the night you served her?
I obviously didn't know that at the time, but with these case materials, yes.
Your bar had a reputation for serving minors?
Oh, well, the bar I inherited, it was called Nats at the time. It had that reputation, so I inherited that, but I made sure not to follow in its footsteps.
Actually, Mr. Mehta, while you owned the bar, it was sued for serving a minor. Do I have that correct?
Yes, there was one incident, yes.
You pled guilty to serving that minor.
Well, the bar pled guilty.
As to character evidence,
Explain.
Your Honor, the plaintiff is using this to try and demonstrate that Mr. Mehta knowingly served a minor in that scenario, and that it happened again, or at the very least, that Mr. Mehta wasn't taking good care to check those IDs. That's improper character evidence.
Ms. Falkel?
First of all, Your Honor, Mr. Mehta did serve a minor in Jessica Marks's case, but we're not actually using it to show what the defense claims. We're using this for credibility.
Before I rule on that issue, and I could be wrong about this, so don't take this as gospel. Isn't this evidence of this prior conviction and the details of this prior incident already in evidence by way of a pre-admitted exhibit, or am I wrong about that?
That's correct as well, Your Honor. Exhibit 1, the plea agreement is pre-admitted.
Okay, so given that that exhibit's pre-admitted and all of this evidence surrounding this prior instance is already in the record, I'm going to allow this line of question to continue. Overruled.
You pled guilty to serving another minor?
As I was saying, my bar pled guilty, so yes.
In that agreement, you agreed to utilize identification scanners on customers who looked younger than 35. Is that true?
Yes, but my personal policy was to check anyone under 45.
Okay, Mr. Mehta. Jessica Marks looked younger than 45?
Yes, she did.
You did not use an ID scanner on Jessica Marks, did you?
It was broken that night, but I would have, yes.
But you didn't.
No, ma'am. As I said, it was broken.
You did, however, card Jessica Marks, right?
Yes.
Showing you what's been marked for identification as Exhibit 3. You recognize this woman in the photo?
Yes, that looks like Jessica Marks.
And this is an identification card.
Yes, a fake one, but yes.
You're familiar with identification cards?
Yes, ma'am.
At this point, the plaintiff moves Exhibit 3 into evidence, Your Honor.
Ms. Rein?
No objection to, Your Honor.
So admitted. Proceed.
Oh, this is a fake identification card, correct, Mr. Mehta?
Yes.
It's a bad fake.
Yes, it's missing quite a bit of accurate information.
You were able to tell that easily.
Yes, ma'am.
You were shown this identification card on March 24th?
I don't remember exactly, but I'll take your word for it.
Yet you still served Jessica Marks alcohol.
Again, if I checked this ID and then it made it past me, that was a mistake on my part, but yes, I did serve her that night.
Thank you, Mr. Mehta. Now, you saw the video earlier, Exhibit
Yes.
10. It was taken at your bar
Yes, I believe so.
at 11:11.
I believe so, yes.
You served Jessica Marks before 11:11.
Yeah, I was serving her throughout that night.
You continued to serve Jessica Marks after 11:11.
Yes.
No further questions, Your Honor.
Ms. Rein, do you have any redirect on that?
Briefly, Your Honor.
Okay.
Mr. Mehta, based on your training, does the law require you to cut someone off if they're buzzed?
No, ma'am. Just if they're showing clear signs of obvious intoxication.
Did you see any one of those signs in Miss Marks that night?
No, ma'am.
Plaintiff talked to you a little bit about that ID. Why didn't you use the ID scanner on Miss Marks?
Well, as I said a minute ago, it was broken that night, sadly.
Mr. Mehta, did you knowingly serve a minor alcohol?
Absolutely not.
Did you look after Miss Marks all night long?
Yes, again, my training is to check constantly, and I did.
Did you ever become any bit concerned about her?
No.
Thank you, Your Honor. I have nothing further.
Ms. Rein, do you have any other evidence to put on, or do you rest?
Your Honor, at this time, the defense rests.
Okay. Ms. Falkel, are you ready to close?
Yes, Your Honor.
All right. Whenever you're ready, you can go ahead and proceed.
May it please the court? Members of the jury, when Jessica's body was found, on March 24th, her BAC was 0.16. That is twice the legal limit for an adult. For a minor like Jessica, it was 16 times the legal limit. Members of the jury, there's a reason that those limits exist. Because with that much alcohol in your system, a person becomes impaired, dangerous. For that reason, when a person becomes obviously intoxicated, the bar serving them must cut them off. On the night of March 24th, Jessica Marks was obviously intoxicated, and the defendant did not cut her off. That's why we've sued the defendant under the Dram Shop Act, Section 25602.1 of the California Business and Professions Code. We had to prove three things to you today by preponderance of the evidence. In other words, we have to prove 50% plus a feather that 1, Jessica Marks was a minor, 2, Jessica Marks was obviously intoxicated, and 3, the defendant's failure to cut her off led to her death. For the first element, members of the jury, the parties do not dispute that Jessica Marks was a minor on March 24th. Moreover, it does not matter whether or not Sonny Mehta knew that she was a minor, just that he served her. Now, that brings us to the second element. Was Jessica Marks obviously intoxicated from the alcohol that was served to her by the defendant? Well, obviously intoxicated means that she was displaying symptoms that would lead a reasonable person to conclude that she was drunk. Sonny Mehta said he didn't see that. He did not observe those signs in Jessica Marks. Well, I'd like to talk a little bit about Mr. Mehta's credibility. In court today, he testified that Jessica was perfectly sober over the course of the night. He said she was sober, but you heard on the stand that when he talked to the police only a day after Jessica's accident, he told them that Jessica was buzzed, tipsy. He would not admit whether he thought sober and buzzed and tipsy are the same thing. The owner of a bar, who, as the defense liked to point out, was exceptionally skilled in identifying signs of intoxication. He would not give you a straight answer. But members of the jury, even if you believe him, when he says that Jessica wasn't intoxicated, well, it doesn't matter if he saw that she was intoxicated or not. What matters is whether he should have seen that she was intoxicated. Ladies and gentlemen of the jury, we know that Jessica Marks was actually drunk, was actually intoxicated. Her BAC was 0.16. She had 10 drinks of alcohol. That's not disputed. But was she displaying signs of intoxication? Well, in the autopsy report that's been published to you, it says that Jessica Marks is only 115 pounds, that she's small, only 5 feet. Members of the jury, she had 10 drinks. That's a lot of alcohol for anyone to take, Jessica Marks included. Now, Morgan Levin also told you that she'd known Jessica for years. The Jessica she saw on March 24th was obviously drunk. But you don't just have to take Morgan Levin's word for it, ladies and gentlemen. You saw the video taken of Jessica Marks that night. Another video was also published to you, a video taken earlier in the night. So you saw a video taken at 8:20 and you saw a video taken at 11:11. And you saw the difference between the two. Jessica Marks was intoxicated in that second video. That's undeniable. So when you heard that the defendant served Jessica Marks before that video was taken, and he served her after that video was taken. That is plenty of opportunity to see Jessica Marks intoxicated. So when he claimed that he didn't see Jessica Marks intoxicated, well, members of the jury, that's not reasonable. We know that they interacted 8 to 10 times. Members of the jury, still, Sonny Mehta did not cut Jessica off. They didn't cut her off, and as a result, her life was cut short. And that is causation, the third element. We had to prove to you that it was the defendant's failure to cut Jessica off that was a substantial factor in her death. Well, you don't have to guess whether the alcohol contributed to her death. In the police report that was published to you, the police officer determined that her cause of death was driving under the influence. She drove under the influence because Sonny's bar served her alcohol. They didn't check her ID. If they did, well, then they saw that it was a fake. You heard Mr. Mehta testify that he could easily see that that ID was a fake, but he still served her. And as a result, her life was cut short. Because of that, we will ask that you find the defendant liable for Jessica's wrongful death. Thank you.
Thank you, counsel. Ms. Rein, when you're ready to go, you can go ahead and proceed.
Yes, Your Honor. She drove her own decisions. Jessica Marks made decisions at the beginning of the night. She made decisions while she was sober, while she knew what she was doing. Ms. Marks made decisions that she knew were dangerous that night. She made decisions hours before she died in that crash. Decisions about driving to a bar, about drinking at that bar, and about driving back home afterwards. She drove her own decisions. Today, the plaintiff is suing Sonny's Rooftop Bar for the wrongful death of Jessica Marks. It was their job to prove to you today, with a preponderance of the evidence, that Sonny's Rooftop Bar served alcohol to an obviously intoxicated minor, and that alcohol caused the death of Jessica Marks. Today, they weren't able to do that because Jessica Marks was never obviously intoxicated, and she drove her own decisions. You heard today from Sonny Mehta. You heard Mr. Mehta knew what the signs of intoxication looked like, that he was over at Ms. Marks's table 8 to 10 times. Mr. Mehta never saw her slurring her words, never saw her stumble or fall, never saw her eyes become red or watery, never saw any signs of intoxication whatsoever. It's true that Ms. Marks had drinks that night, but she had the exact same number of drinks as Morgan Levin. And plaintiff talked a lot about today that she had a blood alcohol level of 0.16. The defense understands that Ms. Marks may have been legally drunk, but in today's case, that simply doesn't matter. The only thing that matters is if the signs of intoxication were there, and they weren't. Ms. Falker brought you Exhibit 10 today, but what does it actually tell you? You heard today from Mr. Mehta, that video is not how Jessica Marks was acting that night. We don't know why that video was filmed. We don't know if Jessica Marks was acting that way to look cool in front of her friends on Instagram. That video doesn't tell you anything. And of the 2 witnesses that actually testified today, only one of them was sober that night. Morgan Levin had been drinking. Sonny Mehta hadn't. Miss Levin told you today that she did feel buzzed. You heard she was beginning to show those symptoms of intoxication. Members of the jury, the plaintiff's entire case rests on the testimony of a witness who had been drinking just as much as Miss Marks. If you think that Jessica Marks was not obviously intoxicated, that the plaintiff hasn't done enough to show that she was, then the case is over. The bar isn't liable, and we can all go home. If you think otherwise, we come to something called an affirmative defense. And what that means is that you have to consider Jessica. You have to consider if Jessica Marks was taking the reasonable care to protect herself that night when she was making those decisions. She started out that night with a glass of wine in her hand. And then she decides not to take a taxi, not to choose a bar she can walk to choose a bar all the way in Malibu. She makes that first decision to drive to that bar. She's had fake IDs all week. She's been using them all week long. She and Miss Levin take their fake IDs to that bar, planning to drink. They've made that plan at the beginning of the night. But before they got to that bar, Jessica Marks had already made her third decision. She'd already made the most important decision of the night. You heard from Miss Levin today that she and Miss Marks had been going to bars all week long, and that after they drank at those bars and those restaurants, they drove back home. Jessica Marks that night had already made the plan to drive back home after she drank at that bar. Members of the jury, she was 19 years old. She knew drinking and driving was dangerous. She knew it was a bad idea. She didn't take the reasonable care to protect herself. Those decisions she made that night were sad, and they were tragic, and they were mistaken. But unfortunately, they're still the decisions that Miss Marks made. Unfortunately, we have to ask you to look at those three decisions and consider how they impacted the rest of the night. Because when Miss Marks got to that bar, she didn't just order one drink. She didn't order one drink and then decide to call a taxi so that she could get home. She kept ordering drinks. She drove her own decisions. She kept ordering those drinks, and she never showed any signs of intoxication. She drove her own decisions. The plaintiff wants you to believe today that Sonny's Rooftop Bar needed to cut Jessica Marks off. But it's not true. Because only if Jessica Marks shows those symptoms of intoxication is that bar liable. And you saw today, that's not what happened. And members of the jury, I'll remind you that Jessica Marks made those decisions at the beginning of the night. She had every opportunity imaginable to make a different decision. And I'm sure the plaintiff and myself both wish that she hadn't chosen to drink and drive. I'm sure we all still wish Ms. Marks was here with us. But unfortunately, members of the jury, she's not. And today, she drove her own decisions. So I'm going to ask you to find Sonny's Rooftop Bar not liable. Thank you.
Thank you, counsel. Ms. Falkel, are you going to give rebuttal? I think you have about 15 seconds, which I'm not sure if you're
I
going to.
believe that's the amount of time I have. Yes, I'd like to give a rebuttal.
Of course. Go ahead.
Jessica decided to drive to the bar. The defendant decided to overserve her. The defendant decided not to take her keys. Jessica's decisions do not disprove the defendant's negligence. Find them liable. Thank you.